um, um, the process of coming up with a contract started with we decided the other contract wasn't working. There were a lot of things. It was too easy for the buyer to change. It was not a time as of the essence contract, which caused some problems post contract in terms of trying to enforce it, because the date didn't mean the date. Approximately was okay. And that was coming up sometimes. So there were some things that we definitely needed to address. And I think everybody here would agree that we needed to address that. So on the Dayton side of things, we decided early on that we had to continue with a joint contract. It only makes sense. So the markets are growing together. All the reasons we thought of 7, 8 years ago when we first did it, we needed a joint contract. So come hell or high water, it was going to be a joint contract. It'd have to be drastic before Dayton would break apart and do our own contract. It came up once or twice, but I don't think it was seriously entertained. So we started working together with Cincinnati, with their group of people working on the contract. The attorney for Cincinnati, the attorney for Dayton was heavily involved, and we met for probably 11 months. We're not even sure how long it was. But what started off was, we're going to address the inspection issue. We might as well just do the whole contract as we started, and it started working through that. So the joint contract that you guys have in front of you, hopefully, is a result of that, but it wasn't just Steve or just the committee. I don't know how many people we had involved at various levels, but probably 70 or 80 between the committees, between the boards of directors. Everybody got input into this contract. The bottom line, there are some differences between Dayton and Cincinnati. I talked about a little bit before. There are customs that are different. There's no laws that are different, but there's just customs that are different in Cincinnati versus Dayton. There's training that's different. There's a lot of this, well, we've always done it this way, right? There's some of that in Cincinnati, things that we haven't done in Dayton. They would say the same thing as with us. So the result of that was there are some compromises in the contract, and we'll probably run across some of them as we go through it in a few minutes. But we decided to, and they decided to, that we can live with it. It's something we can do. Should be no major change, or we gave you the option to change the contract. And then remember also, this contract can be countered, right? If you get an offer and it's something your seller is not comfortable with, you can counteroffer. And vice versa, the buyer can counteroffer what they need to. It's designed to be a working document. Before you get married, the contract should be something that the buyer and seller understand, and hopefully they can live with, and go to a happy closing and everybody's happy and no issues, and so forth. We'll talk about it later. So the contract is meant to be that way, and there are things in the contract that that quite frankly Dayton would have made some different choices, as Cincinnati would have too. But it's a joint contract, so we think that we can live with this. Okay, we'll cover it later on. This is now a real contract. Where it could be argued that the one we're using now, the present one that's going away, was never a real contract. Legally was never really a contract, because the buyer had too many outs in. And this is now a real contract. Paragraph 2 or section 2, you will see time is of the essence. That's a very important legal term. So what we're going to have to get used to on our side of the business is we have to lead our clients to understand that you're signing a real contract. This is real, right? So be sure as possible that you want to do this, that you want to go into it wanting to do this thing, to get married, so to speak, with the seller, and vice versa. It will not be quite as easy to walk away from. So that creates some differences in practice in our businesses. We have to be sure to help our clients with that. We need to make sure, as you'll see in a few minutes, we need to make sure more than before that we understand what this contract is. There are responsibilities in this contract that make us a little nervous, quite frankly, coming out with this. There are timelines and so forth, where our client, the seller, will be stuck doing something because we didn't give a notification. And certainly true of the buyer also. As a broker, as a member of the board, as a realtor with you guys in our community, makes me a little bit nervous. So we'll talk about that as we walk through this a little bit. Okay. With that said, again, we're going to work through this thing, and we want to always know what you guys' input is, right? Some of the things we haven't done before in the field. If we find out that, well, really this is not working or at a large level, be sure to be open about that and give us feedback. Understand that this is the contract. It's not subject to a change today. Right? This is the contract. It's been approved by both boards of directors, and we are going forward on September 1st with this contract. So that said, start getting used to it, and then compile, if you will, and give us feedback about what you're seeing is not working. We will be paying attention, I promise. Right? If you find yourself and your clients counter offering a particular thing too often, we want to know about it. And we'll make the change if necessary going forward. But I think we came out with a real contract, came out with a good process. It was said in the MLS meeting this morning, I think it's really true. There aren't that many changes. There are some profound changes that we'll talk about, but there aren't really that many changes. You'll see that as we go through. Anything else you can think of, Jennifer, that we really need to cover right at the beginning?
Yeah, no, I think it's good. And again, I just, want to reiterate what Steve said. This contract is final, it's finished, but definitely as you are out there and you're working with it, and if you're finding things that just aren't going right or have consequences that maybe weren't intended, reach out to your forms committee, reach out to me. I do keep track of issues, and this is our third round on our joint contract. So every couple of years we do get together, and if there was something really, really major happening, we would reach out to Cincinnati, see if they're having the same issue. But we do hear you, and because some of the things in this contract were as a result of feedback after people started using the 2017 version. So just want to let you know that we do hear you. Give this one a try. I think you're going to be happy in the long run. I think the formatting alone, you're going to find it much, much easier to find things.
Yeah, I would agree. Yeah. And what will not happen, because I won't let it, we will not be stuck with a contract we're not happy with for 5 years. Okay. Because there will be a process where we can look at it again. All right. Okay, Jennifer, let's dig into it.
Okay. Do you want me to bring something up? Want me to bring it up?
Yeah, played around with a lot of different ways to do this session, PowerPoints and all that crap. Now, let's just go through the contract phase by phase, and we'll try to monitor chat, ask any questions and so forth, and we'll go from there. I'm going to point out especially the differences, but also the things that I think will be that make me a little fearful as a broker for all of us. All right. Okay, upper left-hand corner, September 1st of 2021. This contract it was chosen by the board of directors that this is going to go into effect September 1st. This will be the contract. The other contract will not be official effective August 31st. Now, what that means to you guys is that becomes an unapproved form. That would be by using that contract after September 1st, the old contract, you are practicing law. And we tossed around the idea of having a joint contract for a couple of months or something while we got used to it. And the attorneys both said no. We have to have an official contract because that will give us cover in terms of working with a contract form. And as you all know, we don't write contract because we're not attorneys, but by using an approved form, Board of Realtors, it is the form. What we are really doing is filling in the blanks, as you all know. And as the attorneys will continue telling us, think in terms of plain English, right? Don't do fancy stuff. Plain English. Does the seller understand what's being said? What does the buyer understand what's being said? You don't have to be fancy. Just plain English, fill it in, fill in what's supposed to be there. And a judge told me once in a CE class, he said, as long as he understands in a case coming before him, he understands that the buyer and seller both understood what they were signing. They understood what the other person was signing. 90% of his decision is made in any other dispute. And he said, please, when you teach the contract, please convey that. So there, I fulfilled the pledge I made 10 years ago. All right. All right. So it is a legally bound contract and consult an attorney. And please remember, and it'll come up in discussion today, I guarantee that this is our client's contract. It's the buyer and seller, not you. It's not me. It is not you. So make sure it's on behalf of what your buyer wants, what your seller wants, right? Because it's their contract, as we said. Okay, the date there at the top is the offer date, much the same as it is right now. It is the date of offer. It is not the contract date. Contract is not in effect. So the offer date is whatever you put it on there, okay? So there, section 1, not really much change from what was there before. We did change the word a little bit to say, make sure you identify every single parcel on the sale. An experienced person can tell you a war story about when a contract was used and just the address. That should be identifying purposes only. It's the parcel ID that matters, or maybe the legal description, but the parcel ID. So that famous extra lot that's there doesn't really have a street address. If that's on a separate parcel and you intend it to be part of the contract, you got to put it on here. So we definitely included in it. There we gave some extra room, I think. Maybe we did that last time for you to every single parcel. Be verbose, right? Don't try to have, I'm in a hurry because it's 10 o'clock at night. Be verbose. It's very important. If you forget to put a parcel on there, this is the real contract now. It's a possibility that the buyer is only buying the one possible thing. Okay. Section 2 is brand new, the timelines. Okay. Time is of the essence. This is the way the contracts used to be, the way traditionally in common law, it was on real property contracts, right? Time is the effort, of the essence. That's really the first 2 sentences. And what that means legally, if it says September 1st, it means September 1st. Making it September 2nd, no, you've reached the contractor, or you're not meeting the terms of the contract. September 2nd, if it says September 1st, it means September 1st. 10:30 a.m. means 10:30 a.m. Now, the parties, if they need to change the terms for some reason, we forced it into an assigned addendum, or forced it into a counteroffer mode. We've got to get proactive about that. We always should have been. Every broker in the room will tell you this, the problems we have, but you're forced into that now, right now. So there's got to be communication between the realtors. more than what probably is there now. If we've got a lender that's not meeting the deadline, you're not obviously not going to meet the closing date. You've got to communicate with the other agent. And like you always should, do it early on, right? And get the parties to agree, the buyer and the seller to agree what's going to happen. Okay. All right. Good. That's Jennifer's screen, so that's good. So timelines are there. Now, everything starts the day after the contract acceptance date, which we haven't talked about yet. It's not the offer date that we talked about a second ago. It's the contract acceptance date, and everything starts the next day. Number of days for inspection and so forth, all the way through starts the next day. So there's should be no issue. Your clue that we wanted your attention on something is this is a bolded. We paid attention to what's bolded. And if something on this contract is bolded and italicized and underlined, we wanted you to make sure you knew it was there, or the clients too. All right, good. So it starts the day after. Price and terms, very clear. And obviously make sure that this is correct. Make sure it's very clear. The handwritten contract, and it's sloppy. We had one in my office last fall. Everybody went to closing, or half the people went to closing, thinking it was $20,000 difference. We worked it out, but it shouldn't have been that way. It was on a handwritten contract. All right, good. Now the buyer hereby agrees to pay whatever, and it's payable as follows. The first section was changed, and we made it a contingency. It's not technically now, but it is a contingency, and that was done for legal reasons. That if some certain things don't happen in this contingency, the seller has the option to leave the contract. And we'll talk about that as we work through. Earnest money works the same way if the broker's holding the earnest money. So it becomes very simple. The law hasn't changed. And as we all know, we can't always, if it does not close, we can't just release the earnest money because somebody released the contract that does not release the earnest money. The broker can't make the decision the earnest money should go back to the buyer or should go to the seller. We've got to have, if it doesn't close, we've got to have both signatures before we can release it. We've made that clearer in the contract. So we made some extra language in here to do that, that if the broker is holding the earnest money is there. Now on line 14, we had some discussion, it bounced it back and forth in terms of should this still be a blank line? Like how many days do you guys have to collect the earnest money? We ended up, after a lot of talking about it, leaving it blank. You can fill in 3 days, 5 days, whatever you need to get the earnest money. Obviously, if the seller doesn't like that, you can counteroffer that, right? But we added some language in that if you don't put anything in this, it defaults to 3 days. All right.
Steve,
yes.
Do you want me? I've gotten some questions.
Yeah,
Do
sure.
you want me to just cut in? Okay.
Use your judgment. Yeah, for sure. Probably
Okay.
I forgot to cover something.
Since we're in earnest money, I've gotten a couple earnest money questions.
Okay, good.
Let's see here.
As a broker, that's probably the number one question I answer. Always.
Okay.
Yeah.
So one of them. So do we have to change the MLS status from active until this earnest money is received? Okay. And is this contingent on earnest money being given?
Okay, good.
And the third question, why isn't there a checkbox for earnest money going to a third party?
There will be. We haven't gotten there yet. Okay, good. Yeah. So the MLS question is the MLS. The seller and the agent will make the decision. The contract, do you make a part market pending or not? It depends. And the MLSs have rules on that. It's not governed specifically by the contract. that it has to go pending or whatever. And there actually was a little bit of discussion on that. But this is a contract between the buyer and seller. If the buyer wants to make sure it's pending for some reason, you need to insert a term in the contract. It's easy enough to do, right? And make sure the seller signed off on that. But it's not required otherwise, okay, except by MLS rules. All right, does that make sense? The second one was,
Let's see. Is this contingent on earnest money being given?
oh,
And
yeah,
about, you talked about the MLS
yeah,
status.
we'll talk about that. Yeah. So the state law is a state law. We're bound to if the broker's holding the earnest money. So once it goes into our account, it only comes out of in the 4 different, and I'm not going to cover that because that's the same. It hasn't changed, right? So, so you want to scroll down a little bit, please, Jennifer?
Yes.
Just okay. All right. Any questions on this that didn't cover? Okay. Increasingly, as we all know, a third party, a non-broker, is being asked to hold the earnest money, or a situation like it could be a title company. So we've allowed for that now, starting in line 20. I'm sorry, it's starting in line 32. Now, if a broker is not going to hold the earnest money, I will cover just for a second. The title companies, for example, are not covered by the same law. They may very well have a escrow policy in that title company that is totally onerous to the seller. It's not in the seller's best interest whatsoever. They are not covered. They don't have to hold the earnest money. There really isn't much law covering them. So if you're representing the seller in this negotiation, and the earnest money is to go to a title company, let's say, I would think the seller would want to know what the situation is as far as how does that earnest money get released and who, or not. Whatever you decide to do, we've allowed for as starting on line 32. Okay. Right now in the title industry, the title companies are deciding what they want to do. Every title company is different. So do you want to make this contract contingent on separate escrow terms attached to the contract, which means part of the contract, or not? You've got the opportunity to do on 34. We know that the situation is going to continue to evolve. So in terms of what happens, and increasingly there are brokers that don't want to deal with earnest monies. Is that important to the seller in this particular contract? Up to you. We decide, and the seller can make it a part of the contract that the earnest money has to be held by Peter in a jar of mayonnaise on Funkin' Wagner's porch or whatever. Whatever the parties agree to is okay. But if you allow it to go to a title company, you can do that. Okay. But we have one in my brokerage right now that was given to a title company. The seller wants the earnest money. The money's already gone. Title company released it back to the buyer. So yeah,
I do have a question. See, so in the buyer selecting where the earnest money's held, and wouldn't the title company have to follow the contract and its guidelines with earnest money?
Yeah, it's a great question. No. They're not a party to this contract. The contract is between the buyer and the seller. It's not going to come up later on financing. The mortgage company is not a party to this contract. The title companies are not a part of the contract. So it's up to the agents on behalf of the sellers and buyers to say, okay, what's going to happen with the earnest money? To the degree that earnest money is important to the clients, you've got to pay attention. What's going to happen to it? And you always think about what's the worst case scenario. We're all happy. We're all going to go to closing. What if somebody decides not to? And the other party, other party's going to contest that in that situation, as we all know happens. Okay, where's the earnest money, right? Is the earnest money where we want it to be? But the title company is not part of this contract. Very important to understand. Okay. And I would think that this is my thoughts. You guys do what you want to, what your broker says. But my thought is you would want the title companies, what their policy is in terms of how they're going to handle the escrow money. They don't like it. I can tell. They may do it as a favor from you, but the title companies don't like it at all. But if they're holding it to, I would think the seller would want to know. But up to you guys in the individual circumstances. Okay, we okay on this? To move on?
Let's see. Question: if you hold it through title, do we need to provide their escrow terms on a form provided by the title, or is it an addendum we need to create? Line 34.
Yeah, it's not. The contract doesn't require it as written, except if you check escrow terms attached, those terms become part of the contract. Right. Okay. So I would, and then does do you have to do that? No. Do you want to do it? Maybe. Right. In which case you need to be verbose on the subject. Right.
Okay. And let's see, does earnest money have to be collected, or can we mark not applicable this section?
Yeah, not applicable. Yep. Doesn't require earnest money. Right. And I know some of you are brand new to real estate. Yeah, it's not a necessary thing to have earnest money. It can be perfectly valid contract. If it's okay with the seller and buyer, no earnest money is fine. Okay. All right. We okay to move on? Okay. Good.
Okay. Let me scroll down.
Yep, please. All right. So the earnest money comes in. The rest of the purchase price, okay, shall be paid, of course, by wire transfers, so official bank or attorney or title company check on the date of closing, subject to terms of the applicable law. I think we made a couple little tiny changes there, but it's not, they are not, okay. If a client, buyer or seller, does something weird, they may be bound by the contract to do something different. If they were to show up at the day of closing with a suitcase full of $42,000 cash, they've breached the contract. They're not allowed to do that. The contract requires something different. Okay. All right. So the good funds law will apply there and so forth. We thank God the number one agenda item was to get the settlement charges off of the last blank on the first page. So we accomplished that. Okay. We moved it up to make it a little more obvious to everyone concerned that buyer's closing costs are included in this if they are, and we moved it up in the contract to make it more obvious. Okay. We changed it to any other fees allowed by the lender in an amount to exceed blank, and make that very clear also, please. Okay. You'll be better served to do that. Any thoughts on that? Is that clear enough? All right. Okay. Then we go into finance contingency. And the different methods of where's the buyer going to come up with this $200,000, right? Except as otherwise stated, buyer shall pay any all fees as a result of them obtaining financing. So we made that very clear that the buyer's fees are the buyers. They do not belong to the seller except if it's stated otherwise. Okay. If the option includes a buyer rescission period, this is new, I think. If there's a rescission period, like on a home equity loan they're using to buy or something like that, the timelines shall include that. If they said they were going to close on October 30th, It's not good to do I'll wait October 30th, and then I've got 3-day rescission period. No, it's up to the buyer to be responsible to make sure that that's included in this. Okay, so it's sufficient time for funds to be available on the day of closing, notwithstanding any 3-day rescission period or something. Okay, so once again, buyer intends to use the real estate, owner occupied or rental, and the buyer needs to declare what they're doing. They're on line 47, and if that changes for some reason during the processing of the contract, during working to closing, that becomes a counteroffer. The seller gets to weigh in on whether the buyer is going to be able to do that or not. Normally, they would say, okay, I would think, but who knows, right? They may have backup offers they want to go to. So make sure you counter this if it changes. All right. So if the buyer is paying cash, Jennifer, if you could scroll up, please. Just scroll a little bit. Okay. If they're paying cash, written confirmation of funds shall be a verifiable document from the funding source, either one, it's attached, or it shall be provided within X number of days. Okay. If buyer fails to provide the documentation, then the seller may walk out of the contract. All right, right here. So it's right here. Then again, the seller is going to be able to see that they have the funds available. Okay. Any questions on that? All right. Or they could be using a conventional loan. Okay. So in which case the conventional loan section is checked. If you could scroll, Jennifer, that'd be great. Okay.
Oops.
All right, good deal. Buyer's obligation to close the contract, again, it's contingent upon the buyer obtaining for the contract fixed or adjustable, no changes there, I don't think. And they can fill in to 80% of the purchase price, no difference there. Okay, you have the option of specifying what specifically type of loan and this thing. If the buyer wants to make this contingent on their ability to get an 80% loan, for example. Okay, you can fill that in. Okay, FHA government loan, we added USDA on here. Okay.
Oh, Steve, I have a question about who provides that documentation?
I would think the buyer would, the buyer would. Okay. And I would think that the seller would insist on that, right? You're telling me it's a conventional loan. I've got multiple offers on this property. What I need to know at the time of offer is I want the documentation, right? So the agents once again communicate on this thing. Right, back and forth. Is that a sufficient proof or not? But the buyer's obligation is contingent upon their obtaining and applying for and obtaining that. Proof as far as their ability to do that may be subject between the agents, right? Or between the seller and buyer. Okay. All right. If they're maintaining that whatever situation is there, they've got to prove the seller may insist on your being able to prove that. Okay. All right. If it's a government loan, we allowed for USDA in this paragraph. I don't know that there was any changes on here. Don't remember anyway. Okay. We gave a checkbox that they've gotten the FHA for your protection, get a home inspection disclosure, and notify the buyer that that's not a substitute for an inspection. Okay. And understand that the whole house and fees must be paid outside of closing, possibly, and not included, and so forth. Just some extra language in there. Any questions on that section? Okay, this is new. Starting on line 63, there was other funding source is now spelled out, and with a blank line. I would think that there are situations you're going to have to use an addendum. That's okay, right? We thought you guys would lynch us because the contract's as long as it is. So just in the situation where it's not covered, the financing is not covered before, other financing source is what that means, and then spell it out. If the seller's not clear and it's important to them, I would think that again, hey buyer, I need you to specify a little bit more. Okay, we gave you some time. If you want to take advantage of it, you can go ahead and get the contract together. Within 3 days, I want the details. Right, you gave the option to do that. Okay. If the buyer doesn't give the documentation that the seller wants or that they agreed on, then the seller can terminate the contract. Okay. And we talked about how many doggone different things we're running across in the field nowadays. And we couldn't get every single possibility on the contract form. So we got another funding source, and the realtors or the clients may have to use an addendum. If you're not happy or clear, use an addendum.
Okay. Would you add gift money for a down payment in this section?
Yeah, you could, or somewhere in the contract that's clear of that. So if they're getting a gift for the down payment, it's something that you all can talk about, right? It's a listing realtor. I've got to step in as where's the money coming from, right? You would put it under other funding source possibly, right? Or spell it out on an addendum. Does it have to be a term of the contract? Right, from the seller's point of view, look, I want to know where that money's coming from, and it's coming from a stock sale or something like that, where it's not a sure thing, it's not cash in the bank. Do you want to make the contract contingent in some way? Okay, so we couldn't cover every possible thing you guys run across. But we thought we were going to emphasize to you guys, talk. Right, and get it onto an addendum.
The question: who would decide if a hard money lender giving cash to their client is marked here instead of cash?
It's going to be up to the agent writing the offer. Might put it in either one. We know that, right? You might get the financing source from the buyer is very important to the seller, especially in a multiple offer situation. So talk. Right? Where's the money coming from? Right? In a cash deal, you all know, have experience. I want to know where the cash is coming from. Great that you're a cash buyer, but where's it coming from? Geez, it wouldn't be the end of the world if you have to talk to the other agent. And the other agent is got an offer pending on a house with a buyer. They will be open to communication at that point. Find out what you got to know, and whatever needs to be on the contract, amend the contract. Okay. So rather than putting 28 blank lines in here, so there's room, we figured the agents would talk. All right. And everything's changing, as you know, the funding sources are getting interesting. So let's put it that way. Okay. What do I need to know as a seller before I go with your contract? All right. All right. Bold type. Some of it's bold typed and capitalized. So do you think this is important? We want to make sure you got it to your attention. Yeah, of course. If buyer fails to provide written confirmation that the buyer's completed any timeline here, including the 4 coming up, the seller can cancel this contract. So this makes us a little nervous. We talked about this, and they finally decided had to be in there. The seller can get out of the offer, can get out of the contract if the buyer fails to provide this stuff to the seller. So makes me a little nervous. On our behalf, we picked up some liability here, possibly some professional liability if we just goofed off, if we just if we had this stuff and we didn't provide it. So, but we made the choice. We had to, in whole, we had to do that. So the first one, the buyer qualification letter. Okay, we defined a little bit what that does. It's based on the initial credit check and preliminary information. Is that letter not contingent on the other sale of another piece of real estate, or is it? So the seller can know. And is it attached, or blank shall be provided within X number of days? So if you're representing this seller, I would think the seller would want to make sure that this is filled in. If you don't have an attached financing approval, yeah, if that happens, the seller, I would think, would want to make sure this is filled in, and then make sure you follow it. Okay. B, the second timeline, the buyer's got to complete a loan application, which provides the lender with the intent to proceed, which is the legal term in financing, right? Defined by the federal government as certain thing, and the lender will use that intent to proceed and start kicking off things. And the lender has responsibilities, starting with the intent to proceed. They can't kick back and lay back and not process the loan. They have to start doing that. Okay. And including payment for the appraisal within X number of days. Okay. We're going to attempt to try to stop this practice of not paying for an appraisal until the inspection period is over. Right. It's clearly that they're supposed to cash the check, pay for the appraisal within so many days, whatever you guys work out. Okay. The buyer has to make a diligent effort to obtain financing. Within the time period, the buyer shall provide written notification to the seller, or the seller can walk out of the contract, as we covered before. Okay. All right. Now the buyer.
I have a question. I want to make sure.
Sure.
I said just why are we having clients pay for an appraisal before we know the inspections can be cleared, resolved?
Okay, this can be countered out if the buyer's not happy with that. But with this situation where the idea is from the realtor's point of view, as well as from the seller's point of view, are they serious about buying this house? They need to have some skin in the game. Okay, again, this is the seller talking about, and really from our standpoint in the business, is the buyer serious about buying this house? They should have some skin in the game before inspections. Now, if the buyer doesn't want to do that, if they want to go into this real contract, if they want to go into it to playing around, well, maybe I'll buy it, maybe I won't. Then you counter this section out. But the pre-printed language in this contract requires that they pay for the appraisal. Then you go into the inspection period. Both parties have skin in the game, right? So it is, the buyer has written a check towards an appraisal, paid for the inspection, obviously. Now let's talk about inspection and condition of the house. Okay. So again, if you're not happy with that, or the buyer's not happy with that, counter it out. See how that goes for you in this market. But at any rate, yeah, this was done on purpose to make this a real contract. Think about this before you write an offer. Okay, we think this is the house. We understand pretty well what the condition of it is. The only thing we got surprised on the inspection by something, and so we're getting out of it, which could happen. In which case they've wasted the money on the appraisal and so forth. Yeah. So again, counter it out. Okay, but the standard form allows for that, or it makes that happen. All right. Okay, buyer's lender providing written notice within so many days, whatever you fill in there, the conditional approval has been obtained. And then we define what a conditional approval is. Okay. What's credit worthiness? At whatever point, they've got a conditional approval within X number of days. Okay. And there. Now, we left out a blank line. We talked a lot about the conditions are getting weird. We know the lenders are backed up, We have situations where nobody can just meet the deadline. So we're allowing flexibility for you guys going into this. If you know right now the lenders are not meeting any deadlines, you got to allow for that, or you should allow for this on the contract, right? So this is a blank line to do that. All right. All right. Then there's a question I see.
Yeah. Line 73. Frequently, agents check the is not box only to discover it is subject to a closing of another property. There
Yeah.
should be bold print here, something to the effect must be the true status of buyer ability to close.
Okay. Maybe you can. We'll make a note of that.
Yeah, yeah. And again, if there are things, my email, jzeller@daytonrealtors.org, send me those so I can start compiling.
Yeah, my email is jzeller@Dayton. Yeah, there's stuff like that. That's what I was talking about before. If it turns out that that's something we really should have addressed and we didn't think about that, for sure, we want to know about it. We want to know about it. Okay. All right, good. Then line 84, the last timeline that's here, buyer or the lender shall provide written notification that clearly close has been obtained or waived within X number of calendars prior to the closing date. Okay, this one works the opposite way. Days prior to closing. As we know, we're getting clear to close the day of closing sometimes right now. Hopefully that's not going to always be the case. But that's happening. So we reverse the way this was written and I'd say within so many days prior to the date of closing. The closing date in the contract becomes important because the time of the essence. If they're supposed to close October 30th, everybody's counting on October 30th. Within so many days prior to day of closing, maybe you'll put in 0. Because that's what's happening now, that's fine. If the seller also approves that, you're good to go. Okay. Okay. The buyer has to make an attempt to obtain financing. They shall provide all lender requested document to the lender in a timely manner. If they don't, as we know, sometimes they don't, they're breaching the contract. And then whatever happens, happens. But the contract requires them to do this. And the buyer, don't sue the agent. The buyer is obtaining, relying on their own understanding of financing and processing required, as well as the legal tax consequences thereof, if any. Okay, the realtor has not made any determination or not told them something. They're relying on their own financing, and they're going into the contract saying that they understand what they're doing on the financing. All right. Okay. Anything else on that section? Okay. Section 5, appraisal contingency. This has been in the contract for a little while now. And the reality is, if the house doesn't appraise, the courts were not making them close anyway. Right. But if you don't like the appraisal contingency, you have the ability to try to counter that out if you don't want to. But if the house does not appraise, the buyer can get out of the contract. Okay.
Is a text message considered written confirmation?
Would you accept that? No, I wouldn't accept it. Not up to me, it's up to my seller, but I wouldn't accept it because there are situations where they has been held to be legally binding, but it's not very strong. It's not very strong. So I rushed. If you're doing, like we all do in practice, because let's face it, attorneys would take weeks to come up with this contract agreement. That's just the way they work. We're doing it at 10:30 on Sunday night. So we tend to operate via text, via phone calls, things like that to get an offer together. But just know it's your job to scramble and get the thing in writing, to get it on a form as quickly as possible. A verbal or a text, I would put in the same category. Maybe it's a little stronger, but it's not a guarantee. Get it onto a form. that the buyer and seller have agreed to whatever terms you agreed to. All right. Okay, good. All right, it's contingent upon a successful appraisal, okay? And we did break this out into two different events. If it's a cash or other funding source offer, if it's contingent on that section, within X number of days, they've got to do that appraisal and notify the seller that they're getting out because the appraisal is short. It's not going to be 30 days down the road. I wouldn't think the seller would allow that. They can counter whatever they want, or the second thing, in the event of a financing a conventional FHA, USD, or a VA, the same time for set forth in section 4 above also becomes the appraisal contingency period. It's not wait until the last minute and then while the house didn't appraise. It's not fair to the seller. So we're going to try to get everything moved. Okay. All right.
I have is the intent to proceed the notification from the buyer's agent / buyer wants the lender to process the loan? Does this need to be in writing?
Yeah, essentially the lender is going to insist on certain events happening, one of which is money usually, but at that point the lender's required to get an intent to proceed. I think they all have documents that say intend to proceed because that's a requirement on this lender. We're using that same date to say to meet that one section above. Okay.
And is sending the lender the contract satisfying? Does this need to be in writing? Is sending the lender the contract satisfying the intent to proceed?
The lender's not a party to this contract. I don't know. Don't really care. Right. This is a contract between the buyer and seller, and this will come up a little bit later in some of our responsibilities. This is a contract between the buyer and seller, and we've got to get used to. I think the long-term brokers here are a little frustrated. We're letting lenders push us around. The business didn't used to be that way. Yeah, darn it. Lender, this is what the contract says. The buyer has agreed to do this and is under contract with the seller to do this. Now, can you meet these dates? And we, being the professionals, have to understand what's going on from the lender's point of view to make sure we don't put them in an impossible position. But we did in a couple of places, made it possible for you as the agent on behalf of the buyer to go to the lender and through the lender, the appraiser, and say, this is what the contract says. You're not running this show. Right? The contract that the buyer said signed with the seller requires whatever to happen. Now, are you going to be able to meet that? If you're not as a lender and the buyer decides to continue with that lender, we find out about it up front, right? And we deal with it with the seller. So you guys are in a much stronger position and hopefully not letting this thing while we're waiting for the lender. The lender can't do it though. That still kind of happens sometimes, of course, right? But from the very start, it's an attitude change on our parts, right? The lender doesn't run the show. We do. The contract is between the buyer and seller. The lender's got to perform according to the contract. And if they can't, let's make the appropriate decisions and get communication happen up front. And we know that by doing this, it may take a little while, but it's going to be a better process for the buyer to buy a house and a better process for the seller. All right. Okay. The buyer may be stuck buying a short appraised house if they don't provide the appraisal contingency required, notification required. And right here, there's those dates to fill in. So our responsibility to do so. All right, so be careful. The buyer doesn't have an open-end appraisal contingency. It ends at some point period. If they have financing, it's going to be tied to the financing, but they can't wait until pull that thing right before closing. as we know has happened a few times. Okay, section 6, inclusions of sale, pretty much all the same things. They're buying the real estate. They're buying the real property, right? And when the deed transfers that real property, it says a legal description. It includes the land, pertinent rights, and all the rest. That's what this contract is all about. We've gone through this and looked at things. The main thing we took out of this, the term built-in was causing problems, understanding problems between the buyer and the seller. What's built in, what's not. So we took the term built in out, and then a couple of things we specified in here. Please, I think on behalf of your brokers, please go through this thing so you understand what's in here. And I think we're gonna have to make sure we do a good job in listing a property. Anything that might be construed by the buyer or seller as being included or not included later, they're thinking it should be different. Take care of that at the time of listing and the MLS. Take care of making sure the seller understands. And then for God's sake, please, when you get the offer, make sure that there's not anything included here that the seller doesn't intend to include. Okay, that's the main thing. Okay, so we spelled out what appliances are normally included, or like ranges, refrigerators, things like that. You may need to scratch this out. Any freestanding countertop appliances shall not be included, because we've had some issues on that unless specifically talked about. And we tried to put some leased items in there too, security alarm and things like that. So an opportunity to check mark those. Okay, those are seldom owned by the owner, but they might be. So, and we can suggest to that. I keep trying to move your contract. Sorry, Jennifer. Can we scroll
that's
up a
okay.
little bit?
Yes.
Well, my screen is objecting, so don't try to make me do that.
I'm like walking and chewing gum. I'm
I
chatting
know.
and scrolling. I'm not that
I'm
good
sorry.
at it.
I'm sorry. We will do this a little differently the next time.
We're a good team.
Okay. All right. Good deal. Okay. Now we gave you the spaces pretty much are there now. The filing items are included or not included through line 120, and be verbose. I think I would say do what your broker says. Do what you think is right. But if there's something in that doubt, like the shed in the backyard is made by Rubbermaid, so therefore it can't be real estate. If you think that somebody's going to get confused, there's no reason not to put it on the contract. It's not included, or it is. Okay. Be verbose on this. This is called save your broker the phone call, please. All right. All right, good deal. Section 7, certification of ownership, pretty much the same thing that's there. Sellers certifying that they own all the items listed above. You're not going to hear from Rent-A-Center a couple of weeks after closing or something. They certify that they own it, that there's no liens and so forth. I don't think there was any change here. Okay. All right. Now, under seller certification, mostly all the same, okay, except we broke it out. We decided the contract is already 11 pages. Why not, right? So we went ahead and broke some of these out to make it clearer to the seller and the buyer what everybody understands. If you're writing the offer, hopefully the listing agent has spelled that in the MLS or the comments, if they had to be, whether it is or is not included in a historic district, lease, and so forth. We put on here lease also, that there's somebody that has leasehold rights. Okay. I would think if you got a tenant in there on a 30-day, the intention is to give them a 30-day notice. The property is subject to a lease. The buyer gets to know, right? So if you're writing an offer, write this according to what you think, what the buyer thinks. And it forces the seller that if something is not correct, It forces them into counteroffer. The main thing is we find out before we have a contract. We don't get surprised later on. Hopefully, right? By something in here. All right. So you can scroll down here. I don't think there's anything really really controversial here. I think M line 152, there's some foreign investment trust tax act that's coming up more and more. Ann Ross, who's on the committee, said she's running into it all the time, where it's a foreign national as a buyer or as a seller, that it would be helpful for the other party in this contract to find out up front, because there are different laws. And this law, by the way, is federal. So federal law really doesn't concern about what's fair in the transaction. The federal government requires it. So the title company is going to have to deal with it, and we'll make it a term of the contract here.
I've got two questions here. Is this where we would put crop rights for a farmer farming land for the seller? And the other question is, who decides foreign national?
Good. But good question, both. Not the foreign national, not you. Okay. If whoever fills this out, if they're incorrect, okay, then we'll find out before closing. The title company will end up finding out, and then we'll have to deal with it. But we're going to try to make that person, the buyer and seller, declare whether they think they are or not, and get it up front. We're trying to get it up front instead of at closing. Now we're trying to deal with this. Okay, this will take care of a good share of the situations, we think. Okay, again, we can't cover everything that might happen, but we're going to try to get it up front. Okay, and the first question, crop rights, yeah, that's going to have to be dealt with in a blank section, right? The buyer gets to know if the seller is sold off the crop rights. They're not going to give the entire estate to the buyer. And so we're going to try to determine in the contract that this is okay with the buyer. Okay, that the crop rights are not included. All right, does that make sense to you guys? Again, that's a special situation, and of course the seller is not selling what appears to be the case. Any farmland, agricultural stuff, there's some issues that come out, CEUV, which we'll talk about later. So if you're someone who deals in farmland, you should know what the issues are. If you don't, and you are in this contract, you better be careful. Get your broker involved at the very start to make sure you're asking the right questions. And crop rights are one of those. Okay, cell towers are another one, right? If there's a cell tower, that's a little unusual. Okay, there's probably some rights that have been signed away. So just deal with that situation. All right. Okay, we okay on that section? Okay, then HOA, condos, bylaws, and so forth. Again, we broke it out. Okay. There is not subject to a homeowners association, is or is not a pending assessment. Okay. It's subject to mandatory fees and so forth. The sellers got to say what the HOA fees are. Okay. Here. And so this is at the time of listing. The listing agent should be asking these questions largely, but if it can, and it should be on the MLS and so forth. But if you're writing the offer, write what you think. This is what the MLS says, or this property is in an HOA. Why I think it's on an HOA. There's nothing in the MLS. You better ask the question. Okay, but we broke it out here, and the seller has some responsibilities, and put what you think. And the all-encompassing line 160, other, right? So just put other there. All right. Okay, seller certifies that to the best of the seller's knowledge, there's no HOA violations, so the buyer doesn't find out later, right? We can't a seller that's lying or just ignorant, we want to give the buyer some cause of action. If it has to happen after closing, the seller breached this contract. Okay, or if the title company finds out from the HOA that they're pending violations, the seller has breached this contract because they maintained that something else was different, gives us the buyer the possible right to get out of the contract. Okay. All right. Okay, and if the seller's got to provide the documents, the appropriate documents to the buyer, okay? And all of that. If there's any of those that can't be provided, like we talked a little bit about minutes of the HOA from the previous 2 years, some of the sellers can't come up with that. Well, if that's important, change this contract accordingly. But we're trying to make sure the buyer gets a complete picture of what it is they're buying. It's only fair, right? And all that stuff is part of it. Okay. And they have to give it within so many days. The line 168, beginning following the contract acceptance date, or the buyer can disapprove the contract. It can disapprove any of the documents within that period of time. Okay. And you've got some blanks to fill in there. All right. Good. And the contract becomes null and void at that time. Once again, you didn't really have a meeting of the minds. You had a piece of document that said you think you do, but now the buyer found out that it was different when they found out what the documents were. So once again, a best practice is at the time of listing, gather all the stuff. Make the sellers gather all the stuff because they're going to need it. Okay. And let's try to determine up front. Okay. Good deal. Yeah, the seller's got to provide, it's line 176, any letter of assessment provided at closing. We talked about whether or not that was actually a buyer expense. And what we collectively decided was only the seller has control of that, and only they have the opportunity through the HOA to object to that. And only the seller really can find out what that fee is. So that's going to become a seller expense. But the buyer's responsible for any lender required documents, okay, from the collection, from the association. Okay, buyer's going to pay the fees required by the lender, and including but not limited and so forth. Okay, now the initial capital infusion that's starting to show up, right? When the property sells, there's a $2,000 initial capital infusion or more, right? The buyer's got to pay that, okay, not the seller, because of the transfer. All right, and sellers shall pay any dues required prior to the date of closing, and later on it becomes the buyer's expenses. The seller's going to pay for the status letter and include any administrative fees included as a result of the transfer, because once again, the seller has input into that and can actually find out what it is. So we made it their responsibility. Again, you not happy with it, counter it. All right. Okay. Any questions on that section? Section 10. Okay. All right. Or section 9, I'm sorry. Okay. Section 10, pretty much the same. Okay. 10, until physical possession is delivered to the buyer, the seller's responsible for anything that happens, right? Seller's maintaining occupancy for a few days after closing, and the roof suddenly fails. I don't know, that was facetious. But the furnace suddenly fails. Who's responsible? The seller. Okay. The seller shall repair or replace any appliances, equipment, and so forth that fail prior to possession changing, except you can make it exceptions here. All right, you may want to, I don't know, but this is a reason for a seller not to keep occupancy. Yeah, that they're responsible if something fails. All right. So then seller agrees to keep it in good repair while they have it. That's very normal. And if it's damaged or destroyed prior to closing, the buyer has the option of proceeding or to terminate the contract if something happens. Okay, might something be disagreed about? Oh, that's a substantial destruction or not? Maybe, but you can't take care of every possible situation. Okay. Okay, buyer and seller in bold type, so it must be important. We wanted to get your attention. A buyer and seller agreed the buyer shall be provided 48-hour prior walkthrough. Okay, that's been in the closing for a while, but also what's here that walkthrough is solely for the purpose of ascertaining that the seller has maintained the real estate. They are under contract to not re-inspect the property. As it says later on, they can't bring Aunt Joe, Uncle Bob, cousin Vinny. They can't bring through. They can walk through within 48 hours, but only to make sure the property is in the same condition as what it said. Don't re-inspect the property. They don't have the right. And we'll re-emphasize that later on. Okay. So, yeah.
I'm sorry. Question. If an occupancy after closing form is used, does that supersede this line in
I
203?
would think it normally would, right? I would think so, because it more specifically, that's a lawyer question. So Steve's just a broker who acts like a lawyer more often than he should. But I would think that it would, but ask your attorney. Okay. Yeah. And I also think that the post occupancy agreement should refer back, this shall supersede any term of in the contract. Okay. But yeah, you've got other issues involved in whether the contract is still valid or not. So, but lawyer's question again. Okay. Well, I'm going to duck on that one. All right. All right. Home warranty. Oh, upon closing, the buyers are responsible for the insurance. And hopefully, even if the seller's maintaining occupancy, they have to provide insurance to cover themselves. But hopefully the buyer is going to go ahead and pick up the insurance at closing. The lender's going to insist on that anyway. Okay. All right. Home warranty board program. I don't think there's any substantial change. I think we worded it a little bit. But that's there. Property disclosure form, again, is in the contract, has been for a while, and we're making the buyer acknowledge that they have or have not received a property disclosure form. Okay, or if the seller has provided the property disclosure, the exemption form. Why is it in the contract? Because as you should know, that if they do not have the property disclosure form provided for by the seller, if they don't have that and they write an offer, they can, by state law, get out of the offer for 30 days or 30 days after the form is provided. So can you write an offer without the disclosure form? Yes. If the buyer chooses to, go ahead and write the offer. They've got up to 30 days to cancel the contract, any contract they go into, and that's state law. And once the seller provides that to them, they've got 3 days. That's state law. Okay. So again, listing realtors, just get it done. Right? Make sure the buyers have it available to them through the MLS, or send it to them right away with the offer to make sure the buyer can't get out of this contract for that reason. But we provided room in section 12 for the buyer to maintain whether they got it or not. There's no misunderstanding. So, okay. Section 13. This is great. The buyer has said in the contract they're maintaining to the seller that they have acknowledged that they have investigated offsite stuff like sexual predators, crime in the neighborhood, whether a city dump is going in down the road, right? Zoning. They've investigated whether or not the property is suitable for their intended use. And this is for the realtors as much as anything else, right? That the buyer's not going to sue the realtor because they found out later that it could be used for any certain purpose. So this puts the onus on the buyer. Then if any lawsuit is available later to the buyer, is because the realtor told them something, and then they have a professional liability. But again, the famous case in Cincy, where a broker got sued for $2 million. Ultimately, they got sued because there was a sexual predator living next door to the $2 million property that was bought. And ultimately, it resulted in a lawsuit against the broker. There's much more to this story, but ultimately came on the broker. The broker got out of it because of this section in the contract. Okay. The buyer acknowledged that they were supposed to investigate that. All right. So there's that. All right. That's what that means. I don't think we changed it one iota. Section 14. Okay. The inspection contingency. This changed a bit. Okay, again, the goal here, the reason why we went through all this exercise was to make this a real contract. We want to provide the method for the buyer to get out of the contract if the house is substantially different than what they bought, but they have to give the seller the opportunity to repair with limited exceptions. Okay, the buyer, once they go into this contract, the seller gets the opportunity to make any repairs. It's a real contract. They can't use the inspection contingency to just walk away. But at the same time, if there's a substantial material defect and the seller won't fix it, this buyer still has the option of getting out of the contract. Okay, we think this is going to be a much better process. And obviously, we talked about the stuff in this section way more than everything else combined.
Yeah. Sorry, I was looking back. Somebody asked me a question
Yeah,
about
sure,
section.
no problem. Okay, I'll go on. Okay, buyer acknowledges they've given the advice, advised by the realtor to do inspections. Any inspections that are of concern to them, we're letting them do. Just a little practice thing on the side. Be very careful. Advise your sellers to be very careful to limit the buyer's right to inspect in any way, because they're picking up liability. We took pains to say in the contract, the buyer's acknowledging that they had the ability to inspect anything they wanted to, that they were not hindered in any way. And you want to keep it that way as much as possible. Because later on, if there's a lawsuit, the buyer can say, I wasn't allowed to see that, or I wasn't. Yeah, that's not a good thing. Not a good thing. All right. All right. Buyer acknowledges that the buyer's been advised to conduct inspections, and they've been provided to make this contract an opportunity to make the contract contingent upon that, and which it is, unless they change it. Okay. All right. The buyer at the buyer's expense, at their expense, has the option to have it inspected by a licensed home inspector or other professionals. We had when the inspection law came out differently than we thought it did, we had to change that language. I'll let your brokers talk to you about what's in that inspection law if they haven't already. But we allowed effect for another professional, like a plumber, inspecting plumbing and so forth, but they have to be qualified to perform the assessments or services in their special area, specific area of expertise. Inspections regarding the physical condition, insurability, and cost of a casualty policy, the boundaries of the real estate and use of the real estate shall be the sole responsibility of the buyer. Okay, pretty clear. All right. The buyer's relying upon their examination of the property. They're relying upon the seller's representations and certification, including those in the contract, and the lead paint disclosure and the property disclosure. They're relying on that in order to make the offer. Okay. There's legal reasons why that language is there. It's good. It's good, believe me. Okay, now during this inspection period, we're going to talk about in a minute, the buyer and the buyer's inspector shall be permitted to the access to the property at reasonable times upon reasonable notice, and the such persons shall be permitted to take photos and videos and so forth in conjunction with that inspection. They can't take a photograph and send it to Aunt Mabel or post it on Facebook or anything like that. We don't have that area. The law is starting to evolve, but what's not evolving, we do not have permission to do those type of photos. But we are in the contract, the seller is giving them permission to take photos and videos in connection with the inspection process. Okay. All right. Just like now, the buyer is going to be responsible for damages that their inspectors do, and they have to make the repairs. Okay. The buyer understands and agrees that the inspection report are not to be considered a list of required repairs. Okay. It's not a shopping list. Whatever's in the inspection report, the buyer also is not going to use that inspection report as a list of required repairs and or corrections. Okay. Buyer understands that the inspection report may include notes that are for informational purposes only. They do not reflect the condition of the real estate. The buyer agrees that the seller is not required to bring the real estate up to standards, current standards, okay, and that are not applicable in the area. Thinks electrical connections, code has changed or something like that. The inspection report and the fact that the inspector noted that doesn't require the seller to fix it to that standard. Yeah, if they want to fix to that standard, you negotiate it out. But it's understood that they're not asking for that stuff, right? And buyer understands that except maybe further agreed in writing, the seller is not responsible for making any repairs that are noted in the inspection report. Then no matter what the inspection report says, it doesn't require the seller to make that repair. Okay, nothing exciting there, I don't think. And then we allowed some space from line 240 to 241 to make sure whether or not they've gotten lead paint disclosure and whether or not they've gotten a pamphlet. Okay, we put that in the contract that we did a while ago because you understand there's a $10,000 federal fine for failure to disclose. Not about talking about any damages, talking about failure to disclose and who's liable for the fine. And it turns out to be $11,000 because there's a $1,000 administrative cost. If they catch you not disclosing, you, the seller, lender, are on the hook. Federal law requires that disclosure happen. So therefore, we're going to put it on the contract for you guys and for the seller too, if you have disclosed to them. All right. This isn't the inspection period, so to speak, but it's again about making the buyer understand it or acknowledge that they've got it. Okay. Now, if the buyer wants to waive inspections, check 247. Okay. We gave the capability. I think this is brand new. The buyer wants to do limited inspections. Okay, which we said, well, the only thing would be termite and lead, which might be lender required, right? Not going to do any inspections. However, these are required by the lender. Okay, it gives you the ability, or if they want to do full inspections. Okay, so again, we acknowledge on the contract that their inspection contingency is unlimited in scope. We haven't limited them in any way. So don't come back on us later on and say, I wasn't allowed to do that, or my realtor didn't tell me I was allowed to. You acknowledged on the contract that you had an unlimited in scope ability to inspect the real estate. Okay. Buyer may, but not required to, conduct an inspection of all qualities, conditions, and aspects of the real estate, the land, the improvements. Okay. And by way of example, it shall include, but is not limited to, survey, fixtures, operating systems, air conditioning and equipment and stuff like that is there. Okay, and we made it there in the paragraph. All right, and then line 254, in accordance with their above election, A, the buyer has a period, we're still calling it the inspection period, of X number of days, okay, blank line, okay, put in whatever you guys work out, beginning on the day following the acceptance date, again, so we don't need to argue about that, to conduct those inspections prior to the end of the inspection period. If it's 14 days, it's 14 days. Okay, before the end of the 14 days, they have to provide the seller a signed written request for the seller to correct any material conditions or matters adversely affecting it. And we're going to call it the defect notice. I will answer the question in advance. Yes, we will have a defect notice by September the 1st. Okay, there's not going to be post-inspection agreement. That was legally an issue. We used it for years, right? But from now on, it will be called the defect notice, and it shall identify the conditions which require the correction. Buyer agrees in bold type that minor routine maintenance and cosmetic items are not considered material. Buyer may not object to those in defect notice. Now, do we know there's going to be arguments about this between buyers and sellers, between agents? Probably, but we can't cover every crazy buyer that's out there, but this gives legal cover for the other party, right? And then hopefully if you've got a buyer, you're talking about this issue, right? Anything cosmetic, anything really minor, we're not talking about that. We're talking about material things, right? So the inspectors, as they should, commonly point out minor stuff. We want them to do that, right? But that doesn't mean the seller's got to repair, all right? Then, or if they decide if the property's okay, they provide the notice to the buyer's satisfaction. The buyer's satisfied, okay, and they have to notify that too. There will be a notice of satisfaction. This is for the seller's protection as well as yours. Okay, the buyer is going to sign that they were satisfied with the property. Okay, is there a third option anywhere in here where the buyer can just walk away? Nope. If there's defects, they have to give the seller the option, okay? The delivery of either notice shall designate the end of the inspection period. It does now, guys. This comes up sometimes, that when you give now under the post-inspection agreement or in the future in the defect notice, as soon as you give that to the seller, your inspection period is over. You might have had 14 days, but you gave a defect notice to the seller after 10, your inspection period is over. And as covers later on, their ability to go into the property is over. They don't have, the buyer doesn't get to just go tromping through the property anytime they want to. They can, while they're inspecting, to decide if they want to write it, they can write it, they can walk through during the inspection period because with the contract gives them the date, and later on they can do a pre-closing walkthrough. That's it. They just can't go through the property. So when the inspection period is over, it's either at that 14 days or whatever you wrote in above, or when the defect notice goes to the seller. Okay.
Steve got a question / comment.
Sure.
So having the post-inspection where the buyer makes a request, seller responds, buyer accepts that response. We are now pushing to a defect notice and a written counter offer detailing seller's agreement.
Yeah.
Is this an issue for lenders?
Yeah, I don't know. How would it be? Are the lenders getting involved in the inspection process? I'm not going to, I don't have an impression that they are at any great level. Am I wrong? So again, this is between the buyer and seller. Is the lender going to be involved? They haven't been at a large degree so far.
says because it is a separate PIA form, but a
Right.
counter indicates the contract is being changed.
Yeah, it's just, it may end up being changed in some way that involves price or involves cash in some way. Then it's going to be important for the agents to understand or it's going to be part of the conversation, right? Well, what's the lender going to allow, right? The seller wants to give $3,000 instead of doing this stuff. Well, how do we get the $3,000 to the buyer? Will the lender allow cash? Probably not. If it's a federally insured loan, probably not. So that discussion comes up, right, later on. But the lender's involved really peripherally, but it may become part of the issue. But then when you're countering this back and forth, we're just a little bit ahead of ourselves, but let's talk about it. If this comes back and forth, the seller's going to make some repairs or give them some cash. Again, the agents have to be professional and understand what's the situation, right? Well, what if we sell the writing loan for $28,000? Would that be okay? Yeah, or something like that. No, it's not okay. I didn't suggest that, but yeah, how are we going to get the cash to the buyer? Is there a way to do it? Sometimes there's not, that the lender's going to be okay with. But the lender's only involved in this as a secondary matter, right?
And then if checking the box saying seller will get the estimates, do those need to be provided to the buyer?
Yeah, good question. Doesn't really say, does it? No, I don't think so. Because the seller is going to say, I'm going to fix it or I'm not going to fix it. So there's nothing in this contract that requires that they be given to the buyer. So why would it have to be required? Right? The seller has to make the repairs if they agree to it. They have to make the repairs in a workmanlike manner, of course, and the buyer's going to get to walk through the property to make sure. The buyer may put the requirement on in the agreement. Okay, I'll accept that the seller's going to fix it. I get to walk through when another time walk through the property that's okay. They've agreed to that, right? But yeah. The seller's got to make it in a workmanlike manner, otherwise they didn't fulfill their obligation if they agreed to do it. So yeah, I don't think there's any, you can put it in there that the seller has to provide those estimates, but I don't know that there's a good reason why they would have to. Okay, it's got to be done in a workmanlike manner, no doubt. Okay, we okay?
Okay.
All right. Good. Okay. Now the rest of that bold, big type paragraph. Okay. Consideration period is over when they deliver the defect. In the event the seller if they fail to timely provide any required written notice to the buyer, the seller agrees to the repairs. Squirming in the room. I didn't see any, but there is. I can guarantee you. Brokers are squirming too. Okay. The seller has agreed to do any repairs if the seller ghosts the process, or if the seller doesn't go back to them. The seller has agreed to the request. So we've got to be on our P's and Q's to make sure we meet these deadlines. And again, if you don't like this term, change it in the contract. But that's what the standard contract requires. In Cincinnati, apparently it's a big thing. So they have a problem with a lot of sellers ghosting the process, just disappearing. But we're going to make sure that both parties stay in this contract, stay engaged in the contract. They've got obligations otherwise, possibly. Okay. All right. And the horrible scenario from a broker standpoint, from our standpoint, is the agent blows it, right? The buyer told the agent, okay, here's the defect notice, give this to the seller, give this to the seller's agent, and the agent screws up and doesn't do that, okay? Or the other way around, like we're talking about, the seller agrees or doesn't. They've agreed to, once again, they just didn't deal with the contract. They just disappeared and obligated their seller to some repairs. because the agent screwed up. So yeah, that's a little disquieting, but this was the best. We're trying to make this a real contract again. Okay, but it involves, I'm sorry, the agents have to be pros. The agents have to take this business seriously and so forth. Okay. Okay. And we're trying to make it so this is a better business for you guys, right? You're not writing so many doggone contracts that don't go through. So we're trying to go back to the old way and make it a real contract. All right. All right. So we'll see how this works out. But I think it's the right choice that we made to start with. Okay. So, and section C, if the seller timely delivers a written counter, oh, we defined this defect notice is as a counteroffer. Okay, we're changing the terms under which the buyer is buying the house. If the seller's going back and saying, well, I'll do this, not that, or whatever, anything different, it's a counteroffer. So what does that tell you guys? If they don't come to an agreement on this counteroffer, the contract's going to go away. And we'll see that in a minute. Okay. Okay, they've got to do that within so many days to reach a mutual signed agreement to detail the seller's correction of defects, and the delivery of that during the settlement period shall be the end of the settlement period. Okay, and the events underlined, bold, and italicized. Okay, capitalized. In the event that the parties fail to reach the agreement under this section, the contract is automatically terminated. Okay. All right. So it's a good process. A buyer can still get out of that and so forth. Okay. But it's bound to this contract. They're bound to make the seller make the repairs. Now, section D. We had lots of discussion all the way up to the board of directors. What if the house is discovered during the inspections to have serious mold and their kid is allergic to mold? There's nothing the seller is going to be able to do to remediate that to the buyer's satisfaction. The buyer should be able to get out of the contract if we discover that. And again, this would be from the inspection period. We discover a serious defect, and we define this down to be environmental hazards or structural stuff, like the house is falling down, right? So in situations like that, the buyer is going to be able to get out of the contract to be able to walk away. Or might there be individual circumstances that we argue about whether or not falls under this? Yeah, maybe, but we think it's a minority, and we needed to provide that option for the buyer so the buyer's not stuck with a seller who agrees to remediate the radon or the mold or the asbestos, but the buyer's in a situation where they don't want the house. So there you go. Okay. That's the choices that were made. We'll see how it works out. Okay. We were arguing a lot about the word asbestos, for example. How should that be included? Asbestos is in a lot of houses in tile, floor, things like that. Should they get, but it's not really hazardous. So should we give the buyer the out on that? Ultimately, we just included asbestos because there are circumstances where it is really serious. Okay. All right. So give us for our feedback if that works out differently than we're afraid it's going to. Okay. And we defined what hazardous materials are. Okay, and go from there. So any thoughts or yelling, you want to yell at me or anything about that whole section? Section 14. Those are choices we made. We think it's much better than what we have now. All around. It's fair to the buyer, fair to the seller. We have a much more solid contract with the buyer rights and so forth. Any thoughts? Okay, good. Okay. So 15, property survey. Okay. And if the buyer desires the satisfactory survey, they're very seldom done on transactions anymore because the title company started insuring about around them, whatever, 10 years ago. So they're very seldom done. But if the buyer wants it, they need to make a contingent on that. Okay. All right. Good.
Oh, Steve, got a
Yeah,
question here, just a
sure.
clarification.
Of course.
Other than identified in Part D, buyer needs to give seller option for repairs, and buyer can still use this step to ask for a bunch of repairs as a way to walk away if seller doesn't agree.
Right. Okay. Yeah. So again, let's talk about a crazy buyer. Okay. They're going to use everything they can to get out of the contract. We've got those things. Got it. We can't stop that if they do that, but they will not be in terms of the contract. They will breach in the contract. Anything that's not material, any minor routine stuff, the fact that there's a lot of it, they're breaching the contract. There's no question they're breaching the contract. So the contract is stronger that way. The seller would have a cause of action if they choose to pursue it. And we all know the situation. You can't, for legal reasons, it's impossible. For financial reasons, it may be impossible to bring the lawsuit and all of that. Yeah, who knows? Okay. But under the contract, a buyer that did that unreasonable breached the contract. And you guys, as a good practice thing, ought to be talking to your buyers about that's the situation. We're walking into the agreement, and this is our intention. If that kind of stuff, we should determine that when we determine what the offer price was. Do we want to write an offer on the property or not? But the thing is, the buyer's not going to be able to change their mind once they go in the contract and use that, ask for those things as the way to, in their mind, legally get out of the contract. Those days are gone, right? They should inspect the property, anything open and obvious, they should notice ahead of time before they write the offer. They got to be serious about buying this house. And this is why paying for the appraisal up front doesn't disturb us very much, because they got to be serious about buying this house. And now, if we discover something we didn't know about and it's material and serious in nature, okay, then that we get them an opportunity for them to get that changed. But asking for a bunch of Mickey Mouse stuff that happened to be on the inspection report, they've breached the contract. Okay, does that make sense? That's why, yeah, it's not perfect. It's not going to cover every single situation, but it's a whole lot better, we think. All right. Okay, we okay now? We can go on? Am I boring you yet? All right. Oh, no answers. I'm in trouble. All right. Okay, seller, insurance verification. Is that where we are? Yeah.
Yeah.
Insurance verification. Okay. The buyer's got to determine what kind of insurance they're going to need. Okay. The buyer's relying on is maintaining that I've investigated this. I understand the insurance is going to be required, and they've got 14 days to confirm the insurance policy. Okay. Now, what it is now on their contract now, and nobody seems to know it, but the end of the inspection period is the end of the insurance verification period. And that's come up a few times, and it's been ugly on both sides. Okay. We've changed that now. The insurance verification is 14 days. They've got 14 days to determine if the insurance is going to be required and if it's going to be too expensive or whatever, or if the property can be insured. Every residential structure in Ohio can be insured. There's a FAIR program that even if the insurance company won't take it, they can write the insurance through the state. You've probably never run across it because it's horribly expensive, but it can be insured. So be careful about that. Have your buyers get their insurance up front. Okay. And this becomes not a problem. Yeah, buyer has a right to to terminate within 14 days. Otherwise, the contingency is waived. Seller is under obligation on this contract to make the real estate available for agents and inspectors, okay, to fulfill the terms of the contract. The sellers have to maintain the utilities. That's been in there for a while, okay? And uh, the buyer acknowledges that the buyer is not authorized to be on the premises without a licensed agent unless prior written authorization is obtained from the lender. Okay, right there. In the contract, the buyer is understanding that they're not allowed to be there. Now, if you want the buyer to be there for inspections and you don't want to be, get the permission of the seller. You're okay. But without that express and we put this on here because the state's attitude about this. Right now, the Division of Real Estate is radical on this thing. They're suspending licenses. If a seller maintains that somebody showed up and wasn't supposed to be there, they want to know from the agent, where's your express written permission? And they're suspending licenses. So we made it very clear in here for the buyer. The buyer knows that acknowledging that they're not allowed to be on the property without a licensed agent, and it's got unless permission of the seller has been obtained. Okay. So if you don't want to be there during inspections and you want the buyer to be, get the permission of the seller. Easy, but you have to do it. All right. Okay. Then the contractor grew to 11-page edits anyway, so we had room to put five, however many lines there are, 7 blank lines in there. Why not? Okay. So we just put those 7 lines in there. So you had room to write other stuff, right? That could be part of this. Okay. Title insurance works pretty much the same way as what's in there right now. And there's one change. Let me think of what it was.
Let me see. I've got my change copy. Let
Yeah,
me.
there was something on this. I just I'm drawing a blank.
Title insurance.
I didn't think it was really important.
Let's see where we are at section 19.
Just clarification changes. Okay.
Let's see. Buyer does not select an owner's policy of title insurance at this time. Buyer may have the ability to obtain an owner's policy of title.
It also says, and has sort of, but we clarified a little bit, that if the buyer's going to select policy and they want the seller to pay for it, it's got to happen at time of closing. This thing where the buyer has got 30 days to buy title insurance, don't come back to the seller 30 days after closing, expect the $300 to be paid. Okay, does that make sense? So yeah, they've had that happen another time. So it's got to be happen. It's got to be purchased at the time of closing. All right. Okay, proration. We tried to explain that a little better to the buyer, but it's pretty much the same way. Okay. Long and short, special assessments, same thing. We try to tell the buyer, understand that if it's new construction, they're not going to get full assessment for a period of time later. They're paying lot taxes, and of course, the builders take full advantage of that in qualifying the buyer for financing and everything. There's only lot taxes on there, and there's legendary stories out there of a buyer that found out 2 years after they bought a new construction home, they got assessed for back taxes and so forth. And in one case, I remember locally got thrown out of the house because they couldn't make the payment. So, and ended up losing it in foreclosure. So anyway, we're trying to notify the buyer that what their initial taxes are not going to be their ultimate taxes. Okay. All right.
I've got another question back about title insurance.
About what? Okay.
Title insurance. Question about 2C. Seller shall pay the entire cost of an owner's policy of title insurance when issued, and asking for clarification, When issued in connection with the lender's policy, sellers shall pay the difference between lender and owners.
Yeah, yes, if that's the option that's picked. So the seller's gonna be in the hook, and you know what the title companies tend to do, give the credit, any credit doing that scenario to the buyer. So the seller's gonna pay the full cost of an owner's policy if that's checked. So I would think before you have a seller agree to such a thing, you're going to want to know, you're going to want to know what the cost is going to be so you can figure proceeds for the seller. Do you know in the Cincinnati market that they never figure sellers estimated proceeds? It's just not done down there. That's what I'm told, which is amazing to me. But anyway. Okay. All right. Can we go on? Okay. Yeah. Other prorations and so forth. Whatever available information at seller is at closing is going to be able to, it's going to be used. Okay. Yeah, and then the language is here that any security deposits are going to be turned over to the buyer. Okay, we put that in the contract a while ago to help protect the agents. So when we got it, the seller obviously should turn it over to the buyer. We want to make sure it was in the contract. All right. Okay. Closing service shall be provided by the title company designated by the buyer. The buyer can pick the title company to handle the closing because their interests are being protected. If the seller wants to bring their own title company, go for it. Okay. If they want to pick up the cost, and that's done a little bit, but we're going to designate who's going to close it and go from there. Okay. And the title company is not representing the buyer or the seller. They're representing who? Usually the lender. Okay. Good. Yeah. And the seller can pay any of their expenses they want to out of the closing. Okay. Data closing shall be blank. Okay. It's kind of obscure the way this is. We got lost in the shuffle. We were going to make this a separate line and whatever. It's clear enough. I think we're okay. It's not obscure in any way. And one more thing, starting on 418 there, you pick a date of closing. That matters because the contract is of the date is of the essence, but there's an additional clause in here. If through no fault of the seller or no fault of the buyer, you need some extra time, like a day or so, something less than 7 days, the contract's automatically going to be extended up to 7 days. Okay, because what's going on right now, the lenders aren't able to meet their obligation. Yeah, so we're going to give up to 7 days. And we talked about this quite a bit. Best practices, again, the agents need to talk, right? What's working for the seller? What's working for the buyer? What works? We're not meeting the closing date, but the buyer gets an additional 7 days if this is not their fault. The lender didn't get it done or something happened, right? They get up to 7 additional days. And ideally, this is reduced to an addendum or counteroffer to extend that. Don't just rely on the 7 days, right? Just let everybody know as soon as you can what's going on, see if you can get agreement. But if the seller doesn't agree to extend it, we're not letting them out of the contract just because the buyer had to have an extra couple of days because the lender didn't do it. Okay. All right. So we'll see how that ends up working out. Quite a bit of discussion on that, but we think that's fair to everybody. And then the buyer in this market, the buyer's not homeless because their lender took an extra day or so. All right. So that's the choices we made. All right. Make deed payable, make deed to whatever. Okay. Possession shall be given at closing or on or before. Okay. And the seller gets a free rent unless there's another agreement. Okay. And they pay for the utilities, any repairs and things like that. If the seller fails to vacate as they agreed, they're subject for the buyer's expenses. And that's been upheld a lot of times in local courts, the sellers agreed to do that. Okay. Agency disclosure, we just made a statement that they got it. And then any company specific provisions can be here. MLS or public or is going to be public record. Everybody's okay with that. And everybody's okay with anything verbal. It doesn't count. Doesn't matter if they swore on the stack of Bibles. It doesn't matter, doesn't count. It's got to be reduced to writing. I don't think that's anything different than what's there now. Okay. And that can be broken apart possibly if it comes to a court action, especially. It shall be interpreted and construed, and that's this lawyer language. The seller is the non-foreign entity, essentially. Electronic signatures are okay. Line 471, don't sue the realtors for anything. And line 476, electronic wire fraud, still going on, as I hope everybody's telling you guys, as you're acknowledging. Be careful about that. And any questions regarding legal liability, to call the agent, call a lawyer. Okay. Contract acceptance date on line 49 shall be the date on which all provisions of this contract have been accepted and agreed to by other parties to the contract, and the document has been delivered to the other party. So it's a little bit different there, where it's defined right now as the date of the last acceptance. But we defined it a little differently on here to try to reflect some stuff that's happened in the field. But that will be the contract acceptance date. Contract performance dates and so forth flow from the contract acceptance date. Now I'm going to say this again, if I remember right. Good practice, you guys, will be get an agreement with the other agent as to what the date is that went into effect. Reduce it to writing, exchange text, whatever. You guys, it's a best practice. What's the contract acceptance date? Because later on, the 14th day is going to be in contention. Were they within their requirements or not? Get an agreement up front as to what the contract acceptance date was. You won't be arguing about, well, the text says it was accepted. No, agreed on what they were. Okay. We kind of forget that when I rate the offer has an expiration date also. So here's the offer. This offer expires when? Okay, you put it in there. After that time, because time is of the essence, it's no longer valid. Okay, anything answered after that date and time becomes an offer from the seller to the buyer, and you don't have an accepted contract. Okay, all the people that are supposed to sign on behalf of the buyer are signing. Same thing is true of the seller. We allowed a little extra room for entities. If the seller is an LLC, if the owner is an LLC, or so forth, it can go in there. Okay, the seller has the choice of accepting the offer, of rejecting the offer, counter offering, and again, everybody's got to sign off. Okay, pretty much the same way it is now with authorized party added. Now the contract is much the same as it is right now. There are things brought out to make clarification. The contract, there are fundamental differences. And my recommendation is, the board hasn't said that we're going to do this yet, but we're going to. I'm going to make sure we do, that there's going to be a form for you to take everything out of this contract, all the dates, the due dates, the expiration dates, and so forth, and write it. It's not going to be part of the contract, but you're going to write it for your own use on one form. When's this contract expire? When does the inspection period work hard? Since he's had a form like that for a while, and we're going to provide you guys the same thing if I have to do it, okay? And it's mostly self-preservation for the brokers, for us, right? Because we're going to forget. We're going to have 6 or 7 or 8 of these things going, and we're going to forget what the different dates are and so forth. So get it out into some format that you guys, you don't have to do it, but I think it's a best practice. You're stuck taking my class, so you get to hear that. All right. All right. Everything underneath that, we took lines off of that informational or administrative purpose. We took the line numbers off to make it clear this is not part of the contract. You can completely blow the contract acceptance date here. It doesn't matter. The contract acceptance date is still the same. So if you don't fill out this thing, it doesn't affect the contract between the buyer and seller. We should fill it out, help a title company out, right? Help the other agent out, fill this thing out. You're a bad player if you don't. Okay, got it. But it's not part of the contract. All right. The contract acceptance date, put it on there and see if you can agree. I think I would get a separate communication. Okay. Receipt of the earnest money deposit is there for your convenience. Use it or don't use it. Whatever works out. This doesn't apply in all situations, obviously, right? So just use it. It's there if you want to use it. And then the title, lender, administrative processing is there. And again, it'll make a smoother transaction if you go ahead and provide that to the title company. They're not scrambling around the day before closing, trying to find out how to call you. Okay, and so forth. All right. Okay, that's it pretty much. Anything else, Jennifer, you can think of we should have covered that I completely blew?
No, I'm impressed. A little over 2 hours.
Yeah. So yeah, so this is why it's not CE. One of the reasons why this wasn't CE. We don't want to keep you guys any longer than we had to have it. But
so I do have a question. See, if a third party's holding earnest money, they would have to provide a separate receipt, not using this contract.
They don't have to. It's whatever the parties, the buyer and seller agree, demand or agree on the contract. So if the buyer is going to say in the offer, the earnest money is going to be held by a third party, they don't even have to say on the contract who's being held by. I would think the seller would insist who's it being held by. I would think the seller would want to know what the terms are. But again, it's free. If you don't ask, if the listing agent doesn't ask, the seller doesn't ask, there's no requirement to do so. And again, every single title company has their own policies. So yeah, you've got an opportunity to step up and ask for it in the offer. So.
And let's see, a question, should that section about earnest money be required for line 13, or can written acknowledgement be a text or email?
All according to what the parties have agreed to. So yeah, if it requires the notification to go to the seller, okay, and you want to do it via text or so forth, get an acknowledgement from the listing realtor or the seller that this is good. This is good. But yeah, that's a good question, actually, Barry. Does that fulfill? Does that fulfill what's obligated in the contract? I don't know. Yeah. So I think get an acknowledgement from the other agent that they've gotten, right? They've got it, and that you should be good to go.
Okay.
That's a problem with text in general. The court wants to know down the road, prove that they got it, right? Prove that they got it 2 years from now when it's a court case. And that's a problem. So, all right. Yeah, main thing is the main purpose of all this is so your broker doesn't get yelled at. This is a broker talking. Okay, what did I miss? What else you guys want to know? Brokers in the room, anything that should be different from
do you want me to unmute.
Yeah. Oh, yes.
Okay,
please.
let me
Yeah,
go in.
please.
I'm going to stop this share.
I'm
I'm
brave.
going to
I'm good.
unmute. We just have to, let me find out where my unmute everybody is. Okay, it's my manage. Want to unmute.
Can you hear me?
Yes. Yes.
I
Yeah,
have
you
a
can
question
unmute
for
yourselves. Yeah.
Okay, I have a question for you. Why would they not add to line 329 a clause, another sentence that says seller agrees that buyer may attend inspection without agent? If that's it's dangerous with that not being in there automatically. That leaves it up to the agent to add it. Most agents are going to forget that. And you're telling me you're telling us, I should say, division is jerking license because agents are failing to put that in.
Yeah, they're going to do it when somebody's complaining, right? When the seller is usually is complaining, and that's one of their responses has been very clear. This may evolve as it may become normal not to do it, may become normal, but it's not there now. So we'll take your
Yeah, that's a huge, when I explain this contract to my agents, that's a huge risk. They've got to add that sentence in there in that next open paragraph, because every buyer I know, unless they're out of town, they're going with the inspector.
Right. But the only requirement is the agent has to go be there with them. So
Yeah,
if
well,
the agent's not going to be there,
I haven't been doing inspection in 20 years.
Yeah. So then you're going to know you need to modify that if you're not going to do that in the future. That's okay.
Dangerous.
Yeah.
Dangerous.
Yeah. And it may be just come passe that we don't go on inspections.
Why wouldn't the committee, it's too late now, but why wouldn't you add that in as for an ad in the future to protect us all?
So we'll mark that down as a suggestion.
Yeah, please do.
So, and the other side of that coin is the seller claims they didn't see that was there in this 11-page contract, and suddenly where's the agent?
Well, but that's where you're going to double bold it, underline it, italicize it, make it jump off the page at them.
Yeah, and there will be issues like that. I know that will.
That one scares me the most.
Because first of all, the business is changing, the world's changing. So,
I love the new revision. That's the only thing that gives me a huge heartburn.
Okay, duly noted. Great. What else, guys? What else did we miss?
I have a question.
Yeah.
With the added pointed towards essence of time, and a lot of it has to do with us as agents. A lot of it has to do with lenders.
Right, it does.
Has the board reached out to the lender community, tell them that our contract has changed and we're asking them for more responsibility?
Yeah, I think we probably can do something like that because that's come up before. I think having a symposium or whatever for lenders to explain the contract, not a bad idea, Jennifer. That may be something we want to do.
Or we're going to be fighting as agents with some lenders. Yeah.
But kind of like what I said towards the beginning, it gives us the opportunity to, again, assert control of the transaction. This is our contract. It's our process. They're buying through a realtor. And this will ultimately be a reason for a seller to be listed, not sell by owner. There's even more reason because we have control of the whole process. When you list your home with me, there's a defined method for buyers and sellers to buy and sell homes, part of which is the contract, the standard contract. How many contracts are written in Southwest Ohio by realtors a year? 50,000 or more, right? It's an accepted contract. If you want to be a for sale by owner, go for it, but you're out in left field. Yeah, you don't know what's going to happen, but yeah. So the idea is the opportunity is for us to go to the lenders, title companies, all the ancillary services. And I have a client and who is under contract with the opposite party and this contract, this is what obligations we have. Are you going to be able to do this, lender? And if not, we should not put them in a bad position, obviously. If things are happening, we have to be aware of that and make the adjustments. But if we find out up front that this is going to be a problem, then we have to make the adjustments. And we do so with our clients. But again, we're in control. We don't have a lender coming to us and say, don't write it that way, right? Don't do this. We want the contract to say this. Yeah, it's a contract between the seller is a party to this contract too. The buyer or the buyer's lender doesn't get to dictate what's here. The buyer and seller have agreed to something. Okay, can you do this, lender? Lender, if I'm going to keep sending buyers to you, you better start learning to perform, right? Otherwise, if I can't expect that you're going to perform most of the time, I'm going to send buyers to another lender. So try to put you guys back in control. That's all.
But isn't the time to establish whether or not the lender can perform before you sign the contract?
Yeah, we're right.
Okay,
Yeah, and this should be part of the conversation you have with your buyer, right? Yeah.
correct. And the lender.
Yeah, if they're gonna pick Joe's Internet Lending of Schenectady, New York, that has a rate that supposedly is 0.5% below market, yeah, they got a problem now on the contract, or we're gonna have to write the contract accordingly. So yeah, try to bring the business back into the mainstream. So we'll try anyway. It's not going to be perfect. We know that. We know there's odd situations that will come up, but I'll be darned if Quicken's going to continue telling me how this contract's going to keep working. Yeah, if the buyer chooses Quicken, I just picked on them. If the buyer's going to choose Quicken, that's okay, but we've got to write the contract accordingly. Or this is the fallback. Okay, what else, guys?
I have a question.
Yeah.
So, gosh, I lost it already. Hold on, I lost it.
I do that. It gets worse, let me tell you. Okay, while Lori's trying to figure that out, anyone else? Nope. Okay, can you think of?
I'm still kind of confused on what the buyer can and cannot walk away from after inspections.
Okay. Basically, I'm going to boil it basically. They're buying the house. Okay. They're expected to inspect the house and note any deficiencies that are superficial and things like that. So they set up these inspections. They can inspect anything they want to, right? They can inspect the paint. The paint quality. If they want to, they're allowed to inspect it. Okay. Now, at the end of the inspections, what the buyer has agreed to do is at the end of the inspections that they will ask for material stuff, important stuff. That anything not material to the condition of the property. In what way is the property different than what they thought they were going to buy? It turns out the furnace is deficient, or there's not adequate heat, or something like that. Big stuff. It definitely covered. So how is this house different than what you thought you were buying? And that doesn't include paint and stuff like that. They can have it inspected. The quality of the paint, I just picked at random. That's fine. Go ahead and inspect it. The inspectors are going to note stuff like that. That's what they're supposed to do, right? But can the buyer ask for that and stay within the contract? No. So they have to give the seller the opportunity to repair anything material. That's the difference with those exceptions, those environmental structural exceptions. Except for those things, they have to give the seller the opportunity to repair. And if the seller says, no, I'm not going to ask, then this buyer can get out of the contract. But the seller gets the opportunity to repair.
So for example, you see a house and it noticeably does not have gutters. You know, it
Right.
doesn't. It's there. The gutters weren't there during, when you saw it.
Right.
Can you ask for gutters.
As a basic thing,
God.
no. As a
No.
basic thing, I would say no,
Okay.
right? Yeah, because that's open and obvious. It's,
Right.
they're supposed to be inspected, right? And yeah, I would say no. That's open, that's something they're supposed to notice when they inspect it. They acknowledge that they inspected the house. They inspected the neighborhood, right? You don't like the neighborhood. The neighbors got, I don't know, whatever, is mean. Okay, nope,
Hey,
too late. Okay,
Steve, to piggyback off of that question,
yeah,
on line 238, where it says the buyer agrees that the seller is not responsible to bring the real estate improvement up to current building codes.
right.
Does that also include GFCIs, non-grounded outlets, TPR
Yeah.
relief valves, vented
Yes.
exhaust fans to the attic?
Yes, it does. That's something that that is an issue right now. It all comes up always, right?
Always, yeah.
Always. Is that an upgrade? Yeah, it is. We
Perfect.
were talking about this yesterday. It's definitely, so if the seller wants to say no in this contract, they're within their rights to say no. But saying, yeah, that's 40. The problem is the inspections are coming back wanting 10 GFCA outlets. You know, does that, you need that to make the house safe or a code? Probably not. You can argue about that. We're only talking $45 a piece. So the seller sometimes gets on that, but do they have to? No.
But according to the contract, the buyer doesn't have the right to back out because of that.
Exactly.
Correct.
Exactly.
Perfect.
Now, there are some circumstances where if the lender, maybe the appraisal is a different process, of course, okay? The appraiser may come in and require something that's totally different than the inspection process.
Perfect.
If the appraiser requires it, then it's a lending condition and the buyer doesn't get the loan unless the seller fixes it, possibly.
Well, what about your city ordinances where they come through with an inspection
Right,
and they require it?
right. Yeah, are they requiring the seller to do it? Okay, it's being argued about, so don't accept this as gospel, right? But the state has no authority to prevent a transfer, right? So if a city comes in and says there's something that has to be fixed because we require that, well, that might be the case, but the buyer would inherit that condition. Is that something that's a material defect? Maybe or maybe not. Who knows?
Hey, Steve.
That would apply towards the gutter scenario, though.
It might very well. Yeah.
Hey, Steve,
right.
in relation to that, in the seller certification of ownership, line 134, it states that it needs to result in an unconditional certificate on or before the date of closing. So unconditional would be all conditions of transfer.
Interesting.
Regarding,
yeah. Interesting point. So what's happening is the seller certifies that these things are the case, and we set down to E, is or is not subject to a municipal inspection. If it is, then the seller's responsible for fixing that stuff. Right.
So oddly enough, I had an issue where the city of Union required that the blacktop driveway be retopped, but it was in December.
Yeah.
So the buyer had to agree for it to be done X amount of days past the conveyance of sale. But in that case, wouldn't that modify the purchase contract to release a contingency of
Well, it might, it might. What is the purchase contract require or not? And now you've got a city that wants to come in and interfere. And do they have the right to prevent the transfer? There's nothing in state law that allows them to do that.
everybody at once? Anarchy. Anarchy, Attica.
Yeah, there's that. No, but they don't. When the Oakwood's situation, I'm kind of embarrassed for us in a way. You know who got the Oakwood thing stopped for a while? A citizen who said, no, this is an illegal search and seizure. They cannot do that. Took that case to the Ohio Supreme Court, who agreed, said no. They are not allowed. They have no constitutional authority to that. The realtors didn't do it. The builders didn't do it. None of the advocates for property rights did it. This individual owner did that, which was very interesting. So now Oakwood's got a limited one, but they're going through the process a little differently. They do not have the right to just demand this stuff. Hugh Rights is given up there. They can't proceed. If anybody challenges union, do they have the right to? Yeah. On what basis could they stop a sale? Can they show up at the title company and say, don't allow this transfer to happen? No, they can't.
Steve, we're not in a position where we can say to our
Exactly.
client, who may be the seller or the buyer, that, hey, we're going to go ahead with this regardless of that. So I'm not
Absolutely.
going down that path. That's not a
Yeah, you're
viable
absolutely
argument.
correct. Yep, of course. Yeah. So let the clients maintain whatever clients maintain. And when we're having discussion about this, it's just us talking. It's just friends talking in the business, right? But as far as the clients are concerned, the seller maintains something is the case. The buyer accepts it or doesn't, and the various things happen there. Okay. What else?
I remembered my question.
Oh, great.
Okay, so let's say it's time for closing, the buyer or seller's fault, not their fault. We get that 7-day extension period. Everybody agrees on it. Do we still need to complete the form? I didn't hear what you said on that.
Which form?
In the past, we've got a form that we use that.
Well, technically you wouldn't have to. I would think it's best practices though, right?
So go ahead and do it anyway, even though we
Yeah.
have that 7 days.
If you find out you're not going to be able to close on the 30th of October and it's supposed to close on, why wouldn't everybody just talk about that? But if the seller objects, no, I want to close October 30th, the buyer can assert their rights, which I've got 7 days because of this issue. Does that make sense?
Yeah, but I'm just asking about getting a form during that 7-day period. Are you still recommending that we use that no matter what?
For the agreement, for them to come, yeah, it's always preferable if you can get the written agreement. You bet.
Okay.
Do what your broker says. Not me.
May I ask a question to that?
Sure.
If you bring out that form, aren't you saying by bringing out a form that maybe that sentence in there is not defendable?
Maybe.
Doesn't that raise a question?
Yeah, maybe. It's an issue for the next forums committee. You're right. Yeah, you may be right. You may very well be right.
If you extend it 7 days by an addendum, do you then have 14 days because you have 7 more after that for the
Depends on
contract?
how that's written. Yeah, it depends on how that's written, of course.
Oh, my God.
It's not really that complicated, guys. So,
I just have a question about.
Jenny? Oh, I'm sorry. Thought that was you. Anyone else?
Yeah, regarding the inspection,
Yeah.
just to go back and touch on that briefly. So the GFCIs are typically one things that come up as the habitability items from safety because it's an upgrade, or bathroom vents going into attics versus outside, depending upon the age of the house.
Yeah.
So with this new contract, are you saying that if a buyer requests that and a seller doesn't do those things, the buyer cannot get out of the contract?
Well, I'm not going to be the attorney, but that's the idea. Yeah. Because that's if the buyer tries to walk for something that's not important, then what happens, you're not going to be able to force them to close ever, but they're in breach of contract because the seller is going to say, "What? That's an upgrade, or that's not material, or whatever." Right? So you're not going to be able to force them to close. But again, the seller might have a cause of action at this point. So,
and at this point, and there's no second tier of inspections though to say these would be upgrades because when it was built to code when it was built. Again, it comes out on that summary of immediate repairs, and you can say these 6, oh yeah, these are important, but the other 7 are not. And then we're in a position of deciphering between code and upgrades.
And we always care what the inspections say, right? But we don't care what the inspector says. We don't care how they characterize it. Really, do you understand my point? the buyer and seller have agreed to this situation, right? Whatever the inspector said or whatever how they characterize it as a major defect or not, that may give you ammunition as far as it's major, but it's not the defining thing, if that makes sense.
So
So,
we just need to set the table up front, which is if it was done to code when the house was built and the inspector calls it out that it's not up to code today, those are things. that
maybe
we
not,
can
yeah.
walk away from the project.
Yeah, guys, we're still gonna have disagreements with inspections, of course we are, right? We're trying to cut down, get everybody on the same page, make it a real contract, and there's still gonna be situations, was this an upgrade? Or was this major, not major? Were you able to see it when you looked at the house? Then you should have considered that in your offer.
How are you?
We're still gonna have arguments about that,
Okay.
okay? What else?
Everything.
Yeah.
They haven't.
So in regard to the inspection, why did they include the lead-based paint or inspection in there? Doesn't that set us up for any older property for the lead-based paint to become a negotiation tool?
No, why is it that, no, it's outside of the inspection right. We pretty much give the buyer the right to do that anyway. And federal law, and somebody needs to mute, yeah, okay, thank you. The federal law on that lead paint, gives the buyer 10 days to inspect unless they waive it.
I understand that, but my question is, if you are the seller of an older house and you are positive that somewhere there's lead-based paint in that property.
Well, you can guarantee there is, right? Yeah.
Well, I mean, you pretty much can assume that somewhere in a property you could find lead-based paint. So
Right.
if a buyer makes an offer and then they do a lead-based paint inspection and they are able to find lead-based paint, can't that become a very significant negative for the seller and or a strong arming tactic for the buyer?
Well, I don't know. What do you guys think? I think the house was built in 1876. It's got lead paint. Teach your kids not to eat their paint. I don't know. Yeah. I don't know. How much
But
of a
my
defect
question
is
is on
it?
this contract, right? Why was it included? That was a change that was made so that the seller can't say, listen, or the buyer can't say, listen, I'm waiving that. So the seller has that insecurity. So why was it included? What was the thinking behind the change?
Well, it's in there to acknowledge that they got the lead paint because we're required to give it to them.
What
The
line are we
sellers
talking about,
required to
Steve?
give it to them. So
What
the
line are
buyers
we talking
acknowledge
about?
They're
What line
got
are
it.
we, what
I'm
line are we
talking
talking
about
about in the contract?
255.
Judy, it's Jim Watkins.
What is it?
Line 255.
Okay, thank you.
Just wanted the seller wanted to know if you guys.
Okay, somebody needs to mute. I'm sorry, I'm not able to hear. Okay, so the 255, they've got a period of X number of days as an inspection period. What's the issue with that?
Okay, so my question is, if a seller has an older home and they
Right.
know there's lead-based paint somewhere, and you have a buyer who does a lead-based paint inspection and they determine that there's lead-based paint, then now you have a quandary because now you have a seller who is aware of lead-based paint, who now has to take care of it. It's extraordinarily expensive. So how do and where you have a buyer who says, I'll take property, but you have to deduct $30,000 for lead-based paint mitigation.
Okay.
How doesn't this contract set both, especially sellers of any older property, up for a significant challenge?
Well, the truth about their property is the truth, but as a basis, but
I understand that.
I'm not sure I follow your point. I'm not sure it's really an issue. It's different than what's there now. I'm trying to.
Sellers turn down offers because the buyer wanted to do lead-based paint inspection. So my
Okay.
question is, by making this routine, why did we make the change? Yes, we had to give a 10-day period, but many times, almost all times, they were waived.
They can waive it, yeah.
But in this case, it's not waivable. And I mean, I can see some of the people that I've seen in the market using that as a strong arm tactic. So I'm just trying to figure out how to work with that.
Yeah, I'm just dense on the subject. I'm sorry, I don't know what, if the house was built in 1920 and you were pretty certain it's lead paint, whether they do an
Right.
inspection or not, it's got lead paint. Do we think that's a
Okay, so if you
problem?
own a $300,000 home that's been redone and repainted and it's perfect, but it was built in 1893. So
Got it.
there's lead-based paint in the southwest corner of the basement wall.
Mhm.
And I'm a savvy buyer and maybe a little shady, and I come in and I say, okay, I'm gonna do lead-based paint inspection. They find it in that little bit of the southwest corner. Now it's in the property. So now the property has to have lead-based paint mitigated, which is a huge expensive issue.
It's huge if it's just in one corner of the basement.
Well, if you find it in one corner, how hard is it gonna be to find it in some more places? I'm just wondering how our sellers of older properties are going to.
I just don't, yeah, I'm not following it as a major problem with the way the contract is written right now.
And
The buyer
that's-
can
it's
get
just
out
me.
based on the environmental problems anyway. The buyer can
Yes,
walk.
but
Oh, I
Steve, I think
understand
the
that.
question is, why is the comment on line 240 that the seller is not required to make any corrections that may be noted in an inspection report? Sounds like to me that the seller is getting a blanket out of the jail. They don't have to do anything. So what's the point in having an inspection if the seller has a caveat like that?
Well, has a caveat that says what? That they don't have to fix it?
Your
So
line, the
240
line in 240 of the new contract says seller is not required to make any correction that may be noted in the inspection reports.
Oh, okay, they're not, so they're gonna argue about it, right? Is the buyer gonna suddenly waive that inspection report? So the reason that the seller's not required, they're not agreeing up front before we get an inspection, before we know what's in the inspection, the seller hasn't agreed as a contractual matter that they're automatically going to make the repair. So the buyer, I would think this is an important issue, right? So the buyer is going to insist on that repair being done, right? So you've got a disagreement, and ultimately the buyer can walk out of the contract, and the seller is going to fix it or not fix it. Right? And then whatever disclosure issues ensue will happen as a result. But all that line means is the seller's not agreeing up front as a contractual matter that they will automatically fix anything that the seller asks for. That's the way that I thought that's been there for a while, actually. Okay.
Is there anywhere where there's a list of what things are considered material and what are not?
No, we talked about that. Yeah, we talked about that with the attorneys. There's no legal definition. We're not going to be able to lock a buyer and seller down into a certain list that this is material, that's not material. We can't solve that, is ultimately what we decided. So, but we define material. What's the material? I don't know. Yeah. Can the board publish a list of these things are material? No, it would be different anyway, every situation. So
Steve, I'm getting ready to check out. I just want to say you did a great job explaining this. I'm really glad I took the time to sit in on it.
You guys were great for hanging in there. I hope it was interesting anyway.
It was well done.
So,
have a great day. Thank you.
Thanks.
Thanks for saying that, Larry. We appreciate it.
Well, yeah, and you too as well. Sorry. I should have.
Okay.
Oh, no.
I'm not in any hurry whatsoever. I'm good till 4 o'clock for sure. What else do we need to talk about? As again, please don't be quiet about it. If you run across things we screwed up and nobody saw it, none of the board of directors or something, please speak up. We might tell you you're wrong, okay? But yeah, please speak up. And this will be, we're not going to change this thing every day or every week or every month. but we're going to compile this thing. And if something's not working, or practices change or something, we're going to be addressing that in the future. And sometimes it'll be just a small change. We can do that, add a sentence or whatever. Doesn't have to be a major revision. But we want to hear from you guys. And also, as I kind of said at the very beginning, please get involved. We want you guys involved at the Board of Realtors. Don't be shy. And the business, our practice is evolving. The market is evolving. The transaction is evolving. So we, more than anything ever before, we need your input. What do you see in the field? What do you need from us? Right? Like that. Would you agree, Jennifer, since I'm talking on your behalf?
Absolutely. Yes.
Okay.
Yes.
All right.
Hey, Steve.
Yeah.
Steve.
Hello?
Yeah, I think
Where else go first?
I think two of us said we have a question. I've got a question. Can you hear me okay?
Yeah, I can now. I didn't quite hear.
Okay, thanks. Okay, so I'm back to the lead-based paint question again. Maybe it's because I too deal with a lot of older homes. So on
Sure.
line 297, 298, it basically says that if you've got those environmental whatever issues,
Right.
that the buyer can walk away without giving the seller a chance to make
repair.
those repairs. Am I
Right.
reading that correctly?
Yep, you are.
And why, and I guess I'm back to that question too, that someone just asked that I didn't understand the answer to. Why was that decision made? Because sometimes it's not that expensive to repair the asbestos and lead-based paint stuff.
Yeah,
So
I
why
will
should you
say-
be able to walk away on just asbestos stuff, which would be, so many of the houses in Oakland?
Yeah, Mindy, that was quite a bit of discussion on the committee, Dayton and Cincinnati and so forth. Should we include that or not? And we kept bouncing it back and forth. And I won't tell you we're dead set for this thing to give them the ability to walk away. But the example kept coming up, and you guys may have had buyers like this before. The buyer's daughter is highly allergic to mold. And it doesn't pretty much matter.
I'm not
what the
questioning
seller-
mold. I'm not questioning asbestos and lead-based paint.
Okay.
They're very different issues.
Okay, is highly allergic to some hazardous substance, mold, lead paint, whatever. We all know, if y'all want some ammunition on lead paint, go to EPA site. They tell you how to mitigate it, just paint over it, right? Don't
but-
try to remove it. But as far as the contract itself is concerned, should that or should that not give the buyer the right to walk? I think it's arguable. I'm not going to maintain one thing one way or the other. This was essentially what everybody decided, as well as the mutual board of directors. So might we take that out in the future? Maybe. Can you counter it out? Yeah. Take it out of the contract. This shall not apply. Counter it out. But there was a strong feeling among some people that we had to give them the ability to walk. I think I mentioned, you guys I mentioned it before. I had a problem with asbestos being on there, right? Asbestos, okay, it's hazardous, got it. If it's free flowing, but there's asbestos floor tiles, asbestos shingles, and so forth. Should that be a term on the contract? Yeah. The collective decision was that needed to be in there. The attorneys weighed in on that. Okay, so therefore it's in the contract. So will we change that ever? Maybe. Make sure you keep letting us know. But that's in the contract. And then
So who do we let know, Steve? Because I think that's going to be one I think we're going to think
if
needs
you're
to change.
if you're running into that situation, let us know at the board for sure. And counter it out if you want to. So just let us know when we look at the contract, we'll take it out. So that's the situation on that one. So I'm not totally Steve. There's not 100% of the terms or the way we did things that I'm in favor of, right? But we had a wide group of people over a long geographic area, and among them, however many realtors are, 10,000 realtors, or probably a little less. This was a collective decision. Collective decisions aren't necessarily accurate, but that's the one we've got. So is your hand up, Mark Loges?
Yeah, sorry. Regarding line 263 and 264, the requirement for estimates for any repairs
Right.
on the deficit or defect notice, pardon me. Two parts. One, when is this new defect notice going to be rolled out? And when
It'll
will
be
it
before September 1st.
Oh, okay, great. And also, can an agent omit checking either box? Because that was never really part of the contract as far as getting quotes. It was
That's
on
correct.
the post.
Yeah.
Yeah, it was on the post inspection, says if available. In fact, I think the exact term says provide quotes if available.
Yeah.
Now this.
Right. I'm sorry. Go ahead.
Well, I was going to say now it seems like it's almost a requirement. Am I wrong about that? Or
If you leave it unchecked, okay, essentially you've got the situation we've got now. And in the middle of trying to work out this repair situation, you're arguing over who has to give the estimates. There is no requirement outside of what may be in the contract. Yeah, it's not proper to say, well, you're the buyer, you're the buyer's agent, you have to provide estimates. What requires that? Okay, so we've got this issue sometimes on the contracts. We thought we can take care of it by putting it on the contract. Yes or no? If the contract goes through, this is the buyer, remember, writing an offer and the seller agreeing or not to the offer. If you let it go through without either one checked, then I think you've got the situation we've got now. Go for it. Right, go for it.
okay, thank you.
Okay, yeah. Lori?
Yes, I have two questions. One is on the lead-based paint. Obviously, you're already given the disclosure that if it's an older home, it's probably going to have lead-based paint somewhere.
Well, don't your sellers say, I don't know, unless they do know?
Well, I mean, I give my buyers the same pamphlet.
Sure.
Okay, so my question is if they want to terminate the contract based on lead-based paint, do they need to provide an inspection report that says that it was found or that it's
No, yeah, not per se, right? Not per se, yeah.
So any home built prior to that date, they can just say, hey, you got
Yeah,
lead.
in which case as a listing agent and the seller, you shouldn't have gone into that contract.
Right, I agree.
Yeah.
Yeah, okay.
Right. So,
All right, my other, I wrote in my notes that you said something about appraisal contingency, but I don't remember what you said or where that was in the contract.
okay. There's a whole section, section 5 of the contract. Buyer always has, unless you counter it out, the buyer's always, the offer is contingent on, the contract is going to be contingent on the successful appraisal. So that when the buyer's going to exercise the option to walk based on the inspection, the appraisal is going to be defined one of two ways. If it's a cash offer, they've got whatever many days you put on there, 14 days or whatever you put. If it's a financed offer, it's going to be defined largely by how the process goes on the financing. So once the appraisal is in, the buyer's on the clock. They've got to notify the seller that they are going to exercise the option. And we all know the lender gets involved too. Will they approve the financing and all of that? That's not going to change. But
Okay.
that's what
So my question is, we get a short appraisal. Does the buyer have to give the seller the option to adjust the price, or can they just walk away?
They can walk.
Okay.
If the contract, as the contract is now, yeah, they can walk.
Okay.
Okay. Okay, anyone else?
Yes, I have a question.
Okay.
As this is concluding on 8/31, what if I have something before that or on that date that I have a listing, what form do I use?
Well, on the listing, we're talking about the listing contract. But you would be practicing law if you wrote a contract on September 1st or after for using the old farm. Now, I will tell you, and I'm one of them, so I'm telling you on behalf of your brokers, go to your broker. And what's going to happen if you get an offer on your property on September the 10th? You've got a listing, you get an offer, and on September 10th, it's on the old form. How do you handle that? Go to your broker. Ask your broker.
Well, I'm thinking I might get the contract on the 31st or the 1st. What happens?
Well, ask your broker. Let your broker tell you. Okay.
Okay.
How to handle that scenario. I won't speak on behalf of your broker.
But actually on the 31st it ends, so.
Right. Well, the contract, the purchase does, yeah. So, yeah, go to your broker for guidance on that.
Okay, thank you.
Okay, you bet.
One more question, if I can. You
Of
said
course.
the offer is valid until whatever time, September 1st, whatever. If we are negotiating beyond that, we negotiate into the 2nd or 3rd. I just want clarification on, I thought you said we were out of contract or we're practicing law or something on that.
Yeah, again, go to your broker. They will be right. It would become not a valid thing, but it's something that's in process. There's a difference of legal opinion I'm finding out. So if we, as lawyers always do, what can we continue in negotiation on something that happened to be September 1st? Well, you know what? This is going to go away. It's only an issue for a while. But what happens if you get an offer, you've got a seller, right? What happens if we get an offer on the old form and it's no longer valid? Well, how should we behave? Okay, ask your broker, right? Because I know of 3 or 4 brokers and they're handling it differently. So these, as I said, we've had a lot of people involved in the process of this. So we're getting a lot of input, and it's interesting. The answer to that question is handled differently. And I don't think we should really take the place of your broker. Let your broker find out and say how they want to handle this.
So you're saying if something goes in a contract tomorrow,
you're okay.
It's going to stretch over. Is there a grace period?
No, if it's in contract on the 1st, you're on the, it's okay. Yeah, there's no questions on, what if you got a listing in the
go into contract on the 1st?
Yeah. We all know that you're going to get offers on the old farm. I wish everybody's attending these classes, but we all know what realtors are like. Mostly our brokers understand what realtors are like. But yeah, we'll get some, then deal with it how your broker says.
So Steve, but your comment is that if you're using the old prior form, then you're practicing law. So
Right.
really, if that's what the attorneys have told you during this course of the new contract, then that's the advice that should be given from the board. And it is not up to a broker to decide that they're going to practice law, that the contracts are dead.
Well, I think above everything else, it's the broker's decision because it's the broker's firm. The broker's responsible. I know what my choice is, and I don't think I'm going to take the place of the broker, of superseding what the broker says, right? I know what I would say for my firm. I know what I've done, what I've said for my firm. When this comes up, I know what we're going to do. But again, if the broker is going to make another choice, take one of the other legal opinions besides what the board attorneys are saying, that's their purview. That's not us to impose this. Remember, the clients can use a roll of toilet paper if they want to, right? The buyer and seller can agree, cannot have a contract if that's what they choose to do. Right. And that's okay. But what's official, we have a lot of cover in using what's official, a lot of legal cover as far as practice of law. But your broker, I know what I think your broker should do, but I won't step into their role. I think that's improper.